Good morning to all of you. I hope all of you are doing great. So let's start today's discussion. Today we are going to discuss MP Civil Judge question paper. So if you people haven't subscribed to our channel, please go and subscribe to our channel and don't forget to press the bell icon. And we have already started with MP Civil Judge Prelims Crash Course. Link is in the description box. Do check it out. So first question for the day is question number 61. Even after clear indication of disinterest, shown by a woman to men, if such man follows her, then under which circumstance it would not constitute an offense of stalking. So this particular question is related with section 354D of Indian Penal Code, right, which is talking about stalking. So the question is, even after clear indication of disinterest shown by a woman to men, if such man follows her, then under which circumstances it would not constitute offense of stalking. Option 1, it was pursued under a law. Option 2, one-sided love affair. Option 3, due to commercial transaction. And option 4, none of the above. So what should be the correct answer? Question number 61. Yes. What should be the correct answer of this question? Anyone? Even after clear indication of disinterest shown by a woman to a man, if such man follows her, then under which circumstances it would not be considered as an offense of stalking? Option 1, if it was pursued under a law. Option 2, one-sided love affair. Option 3, due to commercial transaction. And option 4, none of the above. Question number 61. Yes. So its correct answer will be your option 1. If it was pursued under a law. So if a particular person is pursued under the law, then it would not be considered as an offense, right? So if you will read section 354D of Indian Penal Code, you will come to know that in the cases of stalking, if it is done with due course of law, then it will not be considered as an offense. So its correct answer will be your option 1. Question number 62. Which of the following section of Indian Penal Code is related to the offense of voyeurism? Which of the following section of Indian Penal Code is related with the offense of voyeurism? What should be the correct answer? Yes. What should be the correct answer? Offense of voyeurism. 354A, 354B, 354C, 354D. Under IPC, voyeurism is defined under which section? What should be the correct answer? Yes, Ankita ji, Vinny ji, both of you are correct. Its correct answer will be your 354C, right? Next question. Question number 63. After the amendment by Criminal Law Amendment Act 2013 to the Indian Penal Code, the offense of gang rape is punishable under which section of IPC? After the amendment by Criminal Law Amendment Act 2013, the offense of gang rape is punishable under which section of Indian Penal Code? Section 376, clause 2G. Option 2, section 376B. Option 3, section 376C. And option 4, section 376D. What should be the correct answer? Question number 63. Yes. Hanji. After the amendment by Criminal Law Amendment Act 2013 to the offense to the Indian Penal Code, the offense of gang rape is punishable under Section 376 2G, Section 376B, Section 376C, and Section 376D. So its correct answer should be your option 4, that is Section 376D. Next question, question number 64. Now, this is your first question from Cr.P.C, Criminal Procedure Code 1973. When the person would otherwise be competent to compound an offense under Section 320 of Cr.P.C is dead, then, so they are stating in the question that suppose if a particular person who is competent to compound an offense under Section 320 of Cr.P.C, that particular person is dead, then what can be done? Option 1, legal representative of such person as defined in the Code of Criminal Procedure 1973 can compound the offense with the permission of the court. Option 2, offense can be compounded by any alive eyewitness. Option 3, offense cannot be compounded after the death of the person. Option 4, legal representative of such person as defined in the Code of Civil Procedure 1908 can compound the offense with the consent of the court. What should be the correct answer? Yes, question number 64. When a person who is otherwise competent to compound an offense under Section 320 of Cr.P.C is dead, then such offense can be compounded by option 1, legal representative as defined under Cr.P.C are competent to compound the offense. The offense can be compounded by any alive eyewitness. Then option 3, that offense cannot be compounded after the death of the person, and option 4, legal representative of such person as defined under C.P.C, Code of Civil Procedure 1908 can compound the offense. Now, if you people will check like Section 320 of Cr.P.C, so you will come to know that only the people who are the legal representative under C.P.C can compound the offense after the death of a person who was otherwise competent to compound the offense, right? Next question, question number 65. Under Cr.P.C, after committal of the case, Sessions Court found that another person against whom a prima facie case is made out from the material contained in a case papers have not been included there. So they are simply stating about additional prosecution. Right? Question number 65 is asking in which of the following section, like under which of the following cases, the additional prosecution can be ordered by Session Court. Option 1, Session Court would have no alternative but to wait till the stage of section under Section 319 of Cr.P.C. Option 2, Session Court can issue summons under Section 193 on the basis of record transmitted to him. Option 3, case should be remanded to the committal for magistrate for appropriate action. And option 4, direction should be given to the police to file a separate charge sheet against such accused. Now, they are stating under Cr.P.C, after committal of the case, Session Court found that another person against whom a prima facie case is made out of the material fact contained in the case papers have not been included there. So they are stating that a particular person should have been included as per the prima facie case, but the police people, they have not included that person. Then what will happen? They have to wait under Section 319, like till the stage of 319, that is to file, like to order a additional prosecution. Option 2, Sessions Court can issue summons under Section 193 on the basis of records transmitted to him. Option 3, case should be remanded to the committal magistrate for appropriate option. And option 4, direction should be given to the police to file a separate charge sheet against such additional accused. So its correct answer will be your option 2. That Sessions Court can issue summon under Section 193 on the basis of the record transmitted to him. Yes, Viniji, you are correct. Next question. Question number 66. In relation to FIR lodged under Section 154 of Cr.P.C, which of the following statement is not correct? Or you can say which of the following statement is incorrect? In relation to FIR lodged under Section 154 of Cr.P.C, which of the following statement is not correct? Option 1, it is not a substantive evidence. Option 2, it is merely marks the beginning of the investigation. Option 3, it cannot be used as a previous statement for any purpose. Option 4, the informant need not to be eyewitness. What should be the correct answer? In relation to FIR lodged under Section 154 of Cr.P.C, which of the following statement is incorrect? First, it is not a substantive piece of evidence. Second, it merely marks beginning of the investigation. Option 3, it cannot be used as previous statement for any purpose. Option 4, informant need not to be a eyewitness. What should be the correct answer? Yes. Question number 66. Its correct answer will be option 3. Like if you will read your section 161 of Cr.P.C, so you will come to know that the FIR or any of the previous statement of the witness can be used to contradict him, right? So FIR can be used for contradiction. So that's how we can say that third option is correct. Under section 125 of Cr.P.C, option 1, a daughter can be asked to maintain her father. Option 2, a father can be asked to maintain his minor child. Option 3, a son can be asked to maintain his father. And option 4, all of the above. Under section 125 of Cr.P.C, a daughter can be asked to maintain her father. Option 2, father can be asked to maintain his minor child. Option 3, a son can be asked to maintain his father. And option 4, all of the above. What should be the correct answer? Yes, its correct answer will be all of the above. Next question, question number 68. Under section 2L of Cr.P.C, non-cognizable case offense means. They are stating under section 2L of Cr.P.C, the term non-cognizable offense or case means a case in which option 1, police officer has authority to arrest without warrant. Option 2, police officer has no authority to arrest without warrant. Option 3, police officer above the rank of deputy superintendent of police DSP, okay, DYSP, has power to arrest without warrant. And option 4, none of the above is correct. Non-cognizable offense case means a case in which police officer has authority to arrest without warrant. Option 2, police has no authority to arrest without warrant. Option 3, police officer above the rank of deputy superintendent of police has power to arrest without warrant. And option 4, none of the above is correct. Yes, 68 ka 2 is the correct answer. Next question. Question number 69. Under Cr.P.C, police may arrest any person without an order from the magistrate and without a warrant. Option 1, who commits a cognizable offense in presence of a police officer. Option 2, who has been proclaimed as an offender either under this code or by the order of state government. Option 3, who obstructs a police officer while in execution of his lawful custody. And option 4, in all of the above cases. If you will read section 41, that is talking about arrest without warrant, there you will find the answer of this question. Option 1, who commits a cognizable offense in presence of a police officer. Option 2, who has been proclaimed as an offender either by this code or under or by order of the state government. Option 3, who obstructs a police officer while in execution of his lawful custody. And option 4, in all of the above circumstances. What should be the correct answer? 69. Yes, what should be the correct answer of question 69? Under CR.P.C, police officer may arrest any person without an order from a magistrate and without a warrant who commits a cognizable offense in the presence of the police officer who has been proclaimed as an offender either under this code or by the order of a state government. Option 3, who obstructs a police officer while in execution of his lawful custody. And option 4, in all of the above cases. So its correct answer will be your option 4. That is, in all of the above cases. Next question, question number 70. Under section 357A2 of Criminal Procedure Code, the authority that is authorized to decide quantum of compensation is option 1, Sessions Judge, option 2, Legal Service Authority, option 3, Chief Judicial Magistrate, and option 4, District Magistrate. So under section 357A clause 2 of CR.P.C Criminal Procedure Code, which of the following authority is authorized to decide the quantum of compensation? Sessions Judge, Legal Service Authority, Chief Judicial Magistrate, and District Judge. What should be the correct answer? Which of the following authority is empowered to decide the quantum of compensation or the amount of compensation under section 357A clause 2 of CR.P.C? Now, section 357 clause A, they are simply stating payment to the victim where it has been realized that something wrong has taken place, but actually the accused has not found, right? No person has been considered as an accused, but it has been discovered that yes, the victim has faced some of the problem. So in that case, the legal service authority can decide the quantum of compensation. Yes, Vinny ji, 70 का 2 is the correct answer. Yes, Ankita ji, 69 का 4 is the correct answer. Question number 71. Under section 143 of Negotiable Instrument Act, trial shall be conducted within dash months from the date of filing of complaint. Under section 143 of Negotiable Instrument Act, trial shall be conducted within dash months from the date of filing of the complaint. Option 1, 2 months, option 2, 4 months, option 3, 6 months, option 4, 8 months. Under section 143 of Negotiable Instrument Act, trial shall be conducted within dash months from the date of filing of complaint. 2 months, 4 months, 6 months, 8 months. What should be the correct answer? 2 months, 4 months, 6 months, and 8 months. What should be the correct answer? Question number 71. Under section 143 of Negotiable Instrument Act, trial shall be conducted within dash months from the date of filing of complaint. 2 months, 4 months, 6 months, and 8 months. What should be the correct answer? That is 6 months, right? So yes, Viniji, you are correct. Its correct answer should be your option 3, that is 6 months. Next question, question number 72. The cognizance of offence under section 138 of Negotiable Instrument Act can be taken by judicial magistrate of first class JMFC having territorial jurisdiction at the place. Option 1, where place of issuance of check. Option 2, place of delivery of statutory notice. Option 3, place where the complainant chooses to present the check for encashment by his bank. Option 4, place where the check is dishonored by the bank on which it is withdrawn. What should be the correct answer? Question number 72. Which of the following court has jurisdiction to try a suit regarding section 138 of Negotiable Instrument Act? Option 1, place of issuance of check. Option 2, place of delivery of statutory notice. Option 3, place when the complainant chooses to present the check for encashment by his bank. And option 4, place where the check is dishonored by the bank on which it is withdrawn. What should be the correct answer? Question number 72. Yes. The cognizance of offence under section 138 of Negotiable Instrument Act can be taken by JMFC having territorial jurisdiction at the place. Option 1, place of issuance of check. Option 2, place of delivery of statutory notice. Option 3, place when the complainant chooses to present the check for encashment by his bank. And option 4, place where the check is dishonored by the bank on which it is withdrawn. So its correct answer should be your option 4, right? Place where the check is dishonored by the bank on which it has been shown for withdrawal. Next question, question number 73. A signs an instrument in following terms. Which instrument are promissory note under section 4 of Negotiable Instrument Act 1881? A signs a negotiable A signs a particular instrument. That particular instrument can be considered as promissory note under which circumstances? As per section 4 of Negotiable Instrument Act 1881. Option 1, I promise to pay B or order rupees 500 to be paid on demand. Option 2, I promise to pay B rupees 5,000 and all other sum which shall be due to him. Option 3, I promise to pay B rupees 5,000 first deducting thereout any money which he may owe me. Option 4, I promise to pay B rupees 5,000 10 days after my marriage with C. So in which of the following cases we can say that which kind of instrument can be considered as promissory note? I promise to pay B or order rupees 500 to be paid on demand. Option 2, I promise to pay B rupees 5,000 and all other sum which shall be due to him. Option 3, I promise to pay B rupees 5,000 first deducting thereout any money which he may owe to me. Option 4, I promise to pay B rupees 5,000 10 days after my marriage with C. What should be the correct answer? Yes. Question number 73. What should be the correct answer? Its correct answer is option 1. That is, I promise to pay B rupees 500 to be paid on demand. Question number 74. And which section of Negotiable Instrument Act provides that the offences under Negotiable Instrument Act are compoundable? So which section of Negotiable Instrument Act states that the offences under this particular act is compoundable? Option 1, Section 137, option 2, Section 141, option 3, Section 147, and option 4, Section 149. Under which section of Negotiable Instrument Act the offences are compoundable? 137, 141, 147, and 149. What should be the correct answer? Question number 74. 137, 141, 147, and 149. Under which section the offences under Negotiable Instrument Act are compounded? Yes, question number 74. So, under section 140, 147, 149, or 137, under which section the offences under Negotiable Instrument Act are compoundable? What should be the correct answer? Its correct answer is your section 147. So 3 is the correct answer. Option 3. Next question, question number 75. Offences under Negotiable Instrument Act are triable by option 1, Session Judge, option 2, Judicial Magistrate First Class, option 3, Executive Magistrate, option 4, Judicial Magistrate of Second Class. So the offences under Negotiable Instrument Act are triable by Session Judge, Judicial Magistrate of First Class, Executive Magistrate, and fourth one is saying Judicial Magistrate of Second Class. Session Judge, Judicial Magistrate of First Class, Executive Magistrate, Judicial Magistrate of Second Class. What should be the correct answer? Question number 75. Offences under the Negotiable Instrument Act are triable by Session Judge, Judicial Magistrate of First Class, Judicial Magistrate of Second Class, and Executive Magistrate. Yes, its correct answer will be option 2, Judicial Magistrate of First Class, JMFC. So both of you are correct, Vinny ji, Ankita ji. Now, we are going to discuss MP Prelims Judicial Service Examination 2013 Class 2 Shift 1 question paper. Now, before 2019, 2013 paper was also conducted in 2 shifts. So we are going to discuss that. Now, firstly, we are going to discuss shift 1, question number 1 of 2013. The question is, under Indian Constitution, in performance of his duties, the Attorney General of India shall have right to audience or right of audience, option 1, only in Supreme Court, option 2, only in all high courts of the country, option 3, in all courts of India, option 4, only in Supreme Court and tribunals established by the central government. What should be the correct answer for this question? Under Indian Constitution, in performance of his duties, Attorney General for India shall have the right of audience only in Supreme Court, only in high courts. No, Vinny ji, remember one thing, MP and Delhi dates are never ever going to get clash, because both of these are quite लार्ज स्टेट्स, ठीक है, देयर आर नो चांसेस कि डेट्स क्लैश हो जाए, सो डोंट वरी अबाउट इट. एंड फर्स्टली लेट मी टेल यू, एमपी का इंटरव्यू राउंड इज शेड्यूल्ड टिल 6th of April. इंटरव्यू राउंड ऑफ 2019 फेज 2. तो जब तक वो वाला इंटरव्यू राउंड का फाइनल रिजल्ट नहीं आ जाता है, आफ्टर इंटरव्यू फाइनल रिजल्ट नहीं आ जाता है, तब तक इसका प्रीलिम्स होने के चांसेस नहीं है. So firstly, they will complete one vacancy, then they will switch on another one. So don't worry, there are no chances of clashing the exam. First ka 3 is the correct answer. That is, Attorney General of India is empowered to hear or to write to audience in all courts of India. Next question, question number 2. Under Indian Constitution, नहीं अंकिता जी, 1 का 3 will be the correct answer. As per Article 76, Clause 3, its correct answer should be 3. Now, under Indian Constitution, fundamental duties enshrined under 51A does not include the duty of option 1 to uphold and protect sovereignty of India, option 2 to defend the country when called upon to do so, option 3 to value and preserve rich heritage of composite culture, option 4 to protect the monuments, places and objects of national importance. What should be the correct answer? Which of the following is not a fundamental duty or does not included in fundamental duty? Right? Option 1 to uphold and protect sovereignty of India, option 2 to defend the country when called upon to do so, option 3 to value and preserve rich heritage of our composite culture, option 4 to protect monuments, places and objects of national importance. What should be the correct answer? Yes. Question number 2. Now, this particular question is asked in last year question paper as well, right? So, ideally, what should be the correct answer? That is your option 4. To protect the monument and places and objects of national importance. This particular thing is DP is not included in your fundamental rights, right? Now, next question. Question number 3. Under which article of the Indian Constitution provides for reservation in the matters in promotion in services under the state in favor of scheduled caste and scheduled tribe? So, which particular article of Indian Constitution states or talks about promotion in the service of state government or state reservation? ठीक है? In promotion. This idea is available in which of the following article of Indian Constitution? Option 1, Article 16(4)(a), option 2, Article 16(4)(b), option 3, Article 16(4), and Article 15(4). What should be the correct answer? 16(4)(a), 16(4)(b, Article 16(4), and option 4, Article 15(4). What should be the correct answer? Yes, what should be the correct answer? Question number 3. Yes. 16(4)(b)(2). Ankita ji is saying its correct answer, like, again, I'm repeating the question. Under which article of Indian Constitution provides for reservation in matters of promotion in services under the state in favor of scheduled caste and scheduled tribe? Option 1, Article 16(4)(a), option 2, Article 16(4)(b), option 3, Article 16(4), and option 4, Article 15(4). What should be the correct answer? Its correct answer should be your option 1. That is Article 16(4)(a). That is talking about reservation in promotions for SC and ST in state services. This particular article was added by 77th Constitutional Amendment. Right? Next question. Under Indian Constitution, the Supreme Court may make rules of regulating the practice and procedure of the court with the approval of option 1, Parliament, option 2, President, option 3, Government of India, option 4, none of the above. Yes. Question number 4. What should be the correct answer? Under Indian Constitution, the Supreme Court may make rules of regulating the practice and procedure of the court with the approval of option 1, Parliament, option 2, President, option 3, Government of India, and option 4, none of the above. What should be the correct answer? Fourth option ka yes, option 2 is correct, that is President. So, under Indian Constitution, the Supreme Court may make rules of regulating the practice and procedure of the court with the approval of President of India. Next question, question number 5. Indian National Anthem is the reflection of real India as a country, a confidence of many religious races, communities, and geographical entities. It is a message of unity in diversity. The above phrase of the Supreme Court was taken from which of the following judgment? Option 1, Sanjeev Bhatnagar versus Union of India. Option 2, Union of India versus Naveen Jindal. Option 3, Sushanta Tagore versus Union of India. Option 4, Aruna Roy versus Union of India. What should be the correct answer? Question number 5. Its correct answer is Sanjeev Bhatnagar versus Union of India, right? So its correct answer is option 1. Now, next, right to vote is a. Right to vote is a. Like, right to vote is which kind of right? Option 1, statutory right. Option 2, constitutional right. Option 3, fundamental right. And option 4, customary right. So, right to vote is which kind of right? Right to vote is a statutory right, constitutional right, fundamental right, and customary right. Question number 6. Yes, it is a statutory right, fundamental right, constitutional right, and customary right. What should be the correct answer? If you people remember, we have discussed this question earlier as well. Its correct answer is statutory right. Under section 62 of Representation of People's Act, it talks about right to vote. So it is a statutory right. Question number 7. Under section 41 of Transfer of Property Act 1882, is the statutory application of the law of option 1, waiver, option 2, estoppel, option 3, res judicata, option 4, res sub judice. So section 41 of Transfer of Property Act is the application of option 1, waiver, option 2, estoppel, option 3, res judicata, option 4, res sub judice. Yes, section 41 of Transfer of Property Act is a law relating to, yes. So if you will read section 7 or like section 41 of Transfer of Property Act, it is talking about estoppel by feeding the grant. Okay? Feeding the grant by estoppel. So its correct answer should be your option 2. Right? So 7th ka 2 is the correct answer. Next question, question number 8. Under Transfer of Property Act, in absence of a contract or local uses, monthly lease is terminable by option 1, by 15 days notice expiring, option 2, by 1 month's notice, option 3, by 3 months notice to the opposite party, and option 4, by 60 days notice. Under Transfer of Property Act, in absence of a contract or local uses, the monthly lease is terminable by option 1, 15 days notice expiring, option 2, 1 month notice expiring, option 3, 3 months notice expiring, and option 4, 6 days notice. Yes. So a monthly lease is terminable, okay, by giving a notice of expiration of 15 days. So its correct answer will be option 1. Next question, question number 9. Under Transfer of Property Act, which of the following is not transferable? Option 1, salary of the public officer after it has become payable. Option 2, right to receive offerings. Option 3, right to receive verified compensation amount. Option 4, right to repurchase. So as per section 6 of Transfer of Property Act, which of the following is not transferable? Option 1, salary of a public officer after it has become payable. Option 2, right to receive offerings. Option 3, right to receive verified compensation amount. And option 4, right to repurchase. What should be the correct answer? So as per section 6 clause 1, salary of a public officer after it has become payable cannot be transferred. right? So its correct answer will be option 1. Question number 11. According to Section 54 of Transfer of Property Act, a contract for sale of immovable property. According to Section 54 of Transfer of Property Act, a contract for sale of immovable property. Option 1. Creates any interest in the property. Option 2. Create charge on the property. Option 3. Confer title on the property. Option 4. A contract that a sale of such property shall take place on the terms settled between the parties. A contract for sale of immovable property creates any interest in the property, create charge on the property, confers title of the property, and option 4, a contract that a sale of such property shall take place on terms settled between the parties. Question number 11. As per Section 54 of T.P.A, a contract for sale of immovable property, option 1, creates any interest in the property, confers charge on the property, confers title on the property, and option 4, a contract that a sale of such property shall take place on the terms settled between the parties. So its correct answer is option 4. Next question, question number 12. Under section 151 of C.P.C, inherent power can be exercised by. Under section 151 of Code of Civil Procedure, inherent power can be exercised by. Option 1, Supreme Court. Option 2, High Court. Option 3, District Court. Option 4, any court. Supreme Court, High Court, District Court, any court. Which of the following court can enjoy the power of inherent power under section 151 of C.P.C? What should be the correct answer? Supreme Court, High Court, District Court, any court. Yes. Its correct answer is option 4, that is any court. Next question, question number 13. Under C.P.C 1908, on the death of either party to the suit, after the conclusion of hearing and before the pronouncement of judgment, the suit, option 1, shall abate, option 2, shall not abate, option 3, may abate with the permission of the court, option 4, none of these or none of the above. Under C.P.C 1908, on the death of either party to the suit after the conclusion of hearing and pronouncement and before pronouncement of judgment, the suit, option 1, shall abate, shall not abate, may be abated with the permission of court, and option 4, none of the above. Question number 13. What should be the correct answer? Its correct answer will be that the suit shall not abate. So, as per Order 22, Rule 6, after the conclusion of trial and before the pronouncement of judgment, if any party dies, the suit shall not abate. Question number 14. Under C.P.C 1908, if the court finds at any stage that it has no pecuniary jurisdiction with respect to the subject matter of the suit, it will. Option 1, dismiss the suit. Option 2, proceed with the suit. Option 3, amend the suit. Option 4, return the suit. If the court realizes that it does not have any kind of pecuniary jurisdiction in respect of the subject matter of the suit, it will. Option 1, dismiss the suit. Option 2, proceed with the suit. Option 3, amend the suit. Option 4, return the suit. Dismiss the suit, proceed the suit, amend the suit, and return the suit. What should be the correct answer? Question number 14. Yes, 14th का correct answer will be option 4. That is return the suit. So under Order 10 Rule 7 of CPC, it is talking about returning of plaint or returning of suit. So the suit can be returned in the cases where the court does not have any pecuniary jurisdiction. Under Code of Civil Procedure, which of the following is not a decree? Which of the following is not a decree? Option 1, dismissal of suit in default. Option 2, rejection of plaint. Option 3, dismissal of suit in default and rejection of plaint both. And option 4, none of the above or none. So if you will read section 2 clause 2 section 2 by 2 of definition part, that it's talking about decree, so you can easily understand the answer of this particular question number 15. Under CPC, which of the following is not a decree? Option 1, dismissal of suit in default. Option 2, rejection of plaint. Option 3, dismissal of suit in default and rejection of plaint both. And option 4, none of the above. So its correct answer will be your option 1, that is dismissal of suit in default. If you people have attended the session till now, so please don't forget to like the video and to subscribe to the channel. And from 21st March, we are starting new batch of Judiciary Masterclass. So if any one of you who sincerely looking for the preparation can join for that, right? See you people in the next class. Meanwhile, take care. Bye bye. Stay healthy, all of you.